Welcome to Justice for New York. I'm your host, Charles Collins. All documentation concerning Justice for New York videos can be found at justicefornewyork.com. After filing those and still nothing done, I decided, well, let's put it this way. The Court of Appeals stinks. It's wretched in there. They have no integrity. These judges have placed themselves above the law. They are out to screw people and take away their constitutional rights. So, I went down there, got a pump, crying foul. I sprayed the Court of Appeals with chicken manure on the front. Again, now remember, Saul Greenberg and his crew they've had me 3 times in court, charged me with making threats and everything, which I didn't do, ruled in my favor. That was strike 1. They lost on when I let off the smoke device. They couldn't prove their case. That was strike 2. I closed down the Empire State Plaza and I get a $100 fine. Plus the only thing that's held against me, I got a ticket for parking on pavement when traffic was backed up for miles. Strike 3. They lost that one too. They can't lose again. So whatever they're going to do, they're going to screw people out of their constitutional rights. I got arrested for it. Now, one of the things is, when I was here, one of the TV reporters was crossing the Menands Bridge, and the person there that was videotaping it for me, I always have things videotaped, and they're on my website. I just want to make sure nothing happens to me when nobody's looking, because I don't trust them at all. I gave him copies of my newspapers and why I was doing this. Of course, that was covered up, and the attorney I had that I ended up having to pay for, he never brought it up. He was there. I'm sure he was threatened to not do anything. As a matter of fact, I wrote a complaint about him not doing his job. Of course, the judge said he did a wonderful job of representing me. The arraignment. I was brought before Judge Herrick. Who else? On the criminal mischief charge in the 2nd degree, a Class D felony, and criminal tampering in the 3rd degree, a Class B misdemeanor. And thank goodness they now had a court reporter there, because I have all the transcripts of each one of these hearings, and they are all on my website. Because Judge Herrick deliberately violated my constitutional right to counsel, never informed me of the information that he was required to inform me of by law, and had it not been for the transcript, I would never be able to prove it, because he would state he gave me everything. Okay, transcripts of the proceedings. Court. I'm going to provide you with copies of the charges. You are charged by Officer Tremblay, Albany Police Department. That at roughly 5:45 this morning, I sprayed the Court of Appeals. It is specifically alleged, knowing that you had no right to do so, with the intent to damage the property of another. I had no intent of damaging any property, and no property was damaged under the law. You intentionally sprayed the chicken excrement on a 20-foot by 4-foot tapestry on the front of the building. Total damage in excess of $1,500. I sprayed it, but there was also court testimony. All I had to do was be aired out. There was nothing wrong with it. It wasn't ripped, it wasn't torn, nothing. But we're going to get into that in a little bit. I'm in charge of it. You have the right to an attorney and the right to an adjournment. In order to obtain an attorney, if you cannot afford an attorney, I will appoint one to represent you. Can you afford an attorney? No, I can't. I'm going to enter a plea of not guilty. I will have the public defender speak to you. Right. I'm going to have the illustrious public defenders that did absolutely nothing the last time. I stated I would prefer not to have the public defender's office. The last time I had them, they lied to me. They didn't do their job. They even refused to discuss my case with me. Would you want them for your attorney? You can't even get a hold of them. I stated I will represent myself. I provided you with copies of the charges and some statement. I have not provided you with copies of it yet. Based on the seriousness of these charges, at approximately 6 a.m. on the Court of the People recommend this defendant be remanded to the custody of Albany County with no bail. Everybody gets bail. I didn't do anything. Discuss the bail and everything. They gave me what? It's wiped out. You don't need an order of protection in reference to that. I'm also going to issue an order of protection that directs you to have no illegal contact with Chief Judge K or any members of the Court of Appeals. You are to stay away from the Court of Appeals building while the charges are pending. I'll get you your order of protection in a few minutes. You'll get a telephone call. Hopefully I can get out of jail. Now, that's all he told me. Under New York State law and the Court of Appeals, held that in order for a defendant to waive his right to counsel, he must be informed of certain information. Unfortunately, he didn't give me all the information he was required to. To be valid, this is the New York State Court of Appeals referring to the U.S. Supreme Court in Von Molk. Such waiver must be made with the apprehension and nature of the charge. I was told what the charge. The statutory offenses included within them, the range of allowable punishments thereunder, possible defenses to the charges, and circumstances and mitigation thereof, and all other facts essential to a broad understanding of the whole matter. 1. I was not informed of the range of allowable punishments thereunder. The transcript shows that. Possible defenses to the charge and circumstances and mitigation, and all other facts essential to a broad understanding of the matter. I wasn't entitled to that. So far, Judge Herrick, who's now going to be the new public defender, is still not complying with the law, even after the last time of me being before him. Judge Herrick did not inform me of the advantage and disadvantages of self-representation as required for me to waive my right to counsel. People v. Chapman, New York State Court of Appeals ruling. While a defendant need not have the skill and experience of a lawyer in order to effect such a waiver, he must be made aware of the advantages and disadvantages of proceeding with counsel. He never told me any of that stuff. Question, is Judge Herrick guilty of a criminal act? Is criminal official misconduct? As a criminal court judge, we can assume, one, that he's a public servant, that he knows the criminal procedure law, which we knew before he didn't, because he didn't even know I was entitled to a jury trial, when it was very simple. If you're charged with a misdemeanor, you're entitled to one, but he didn't know that. Neither did the attorneys. That he knew that he had to inform me of the information contained in 18010 that was inherent in his duty. That's official misconduct under the statute. So right now I'm already being deprived of my rights, and I'm just at my first arraignment. The defendant has a right to aid counsel at arraignment and at every subsequent stage of the action. And if he appears at arraignment, has the fine to ask for an adjournment for a purpose of to communicate free of charge by letter or by telephone, to have counsel assigned by the court in any case where he is financially unable to obtain same. Judge Herrick did not inform me I had a right to the aid of counsel at the arraignment and at every subsequent stage of the action. The court must inform the defendant of all rights specified in 2 and 3. The court must accord the defendant opportunity to exercise such right and must itself take affirmative action as is necessary to effectuate them. He took no affirmative action to have counsel appointed for me, except to say, I'm going to give you the public defender's office, which he knew from the last proceeding They violated my rights and didn't do their job. And he expects me to say, oh yes, I will take them? I don't think so. A defendant. This is the most important thing. A defendant, and remember this, a defendant who proceeds at the arraignment without counsel does not waive his right to counsel, and the court must inform him that he continues to have such right. You cannot waive your right to counsel at arraignment. Even if you proceed at arraignment, you cannot waive it at arraignment. I was never informed of this. Cover up. A person who proceeds with my right to counsel before Judge Herrick, he was required to inform me of a lot of information he didn't. Again, what's he going to do now that he's the head of the public defender's office? He's used to working with the DA's office, screwing litigants over. He's going to continue. You know what Fritz did? He didn't care. I don't know who the last one was, but then I got bail. Judge Herrick's, whenever it's convenient, I will put it over a week from today to the 2nd. I have a court date on the 2nd, not criminal. You have your order of protection. Stay away from Chief Judge K. I never went around her. I think you made your statement. I will see you a week from tomorrow. Matter adjourned. Judge Herrick's illegal actions at my arraignment did not comply with the criminal procedure law. Again, all this stuff is on my website. Judge Herrick failed to inform me of the primary purpose of the proceedings upon a felony complaint was to determine whether I should be held for the action of a grand jury with respect to the charge. Judge Herrick did not inform me of my right to a prompt hearing upon the issue of whether there is sufficient evidence to warrant the court in holding me for action of the grand jury. But he may waive such right. I may waive it, but he didn't inform me of this. After I left there, they decided they were going to go to the grand jury. They notified me of the grand jury date. I appeared to give testimony at the grand jury of all went with K. In comes Mr. Horn, who will be shown is nothing but a sniveling little coward and is out to screw people. Before they, when I appeared there, it states, did ADA Horn have the authority for me to sign a waiver of immunity without counsel being present, without a judicial inquiry by a judge? Let's look at the applicable issues. First off, a waiver of immunity obtained in violation of the grand jury witness state constitutional right to counsel is not an effective waiver within the meaning of the law. Accordingly, where a grand jury witness testifies under such constitutionally defective waiver, the witness, whether voluntary or compelled, receives transactional immunity conferred by the statute and cannot thereafter be prosecuted for any matter on which responsive testimony is given. Accordingly, neither his uncounseled waiver of the right to such legal advice nor his immediate ensuing waiver before the grand jury of his statutory right to immunity may be deemed to be valid renunciation of those rights under the state constitution. In other words, regardless of whether he was actually represented at the time he appeared before the grand jury, was indelible right to counsel had attached when the felony claim against him was first filed. And that right continued throughout the criminal proceeding, notwithstanding the order relieving the specific attorney who had represented him at arraignment. Indeed, since the defendant had already been accused of a serious crime, his appearance before the grand jury was unquestionably an occasion when legal advice is critically needed. Mr. Horn does not have the authority to have me waive my right to counsel under any circumstance. He's not a judge. Held that even though the defendant's counsel had been relieved, he was still entitled to counsel. Furthermore, the court ruled that what the judge had informed the defendant of was not sufficient for the defendant to have waived his right to counsel. In my case, I never had a judicial inquiry, and was not informed of any information by a judge. This is far less than what was defended in Chapman. People versus Bartok, and this is how they do it. Inasmuch as the criminal prosecution against the defendant had commenced upon the filing of a felony complaint, his right to counsel indelibly attached thereupon. Accordingly, his grand jury waiver immunity obtained without the benefit of counsel. I didn't have counsel there. They know I didn't have counsel there. Or judicial inquiry. I didn't have a judicial inquiry. There was no judge there. Was ineffective and caused the defendant to be cloaked in transactional immunity. Thus, the indictment must be dismissed. These cases are very clear. In fact, clearly held that the grand jury waiver immunity obtained without the benefit of counsel or judicial inquiry was ineffective and caused the person to be cloaked in immunity. I did not have counsel and there was no judge. Gonzalez, defendant's right to counsel had attached. Again, this is a Court of Appeals ruling. These all are. Had attached at his arraignment, and any statement he made it was inadmissible unless he waived his right to counsel in the presence of counsel. Couldn't waive it in front of counsel because I never had counsel there. White, for a right too easily waived is no right at all. The judge must see to it that the waiver is knowing and intelligent. There was no waiver, knowing and intelligent before any court. The law is, even if I if I waived it at my arraignment, I did not waive my right for counsel for the rest of the proceeding. Claudio, the correlative necessary to provide the defendant with an advocate sufficiently competent to ensure fairness in the adversary criminal process. The right to effective assistance is recognized not for its own sake, but because of the effect it has on the ability of the accused to receive a fair trial. You're not getting a fair trial, especially in Albany County. Based upon the above law, I could not have legally waived my right to counsel and or immunity without counsel being present or a judicial inquiry. The appellate court stated, defendant's contentions to the contrary, notwithstanding the evidence submitted at the hearing before county court, including the grand jury minute, established that defendant effectively waived his right to counsel. Where did I effectively waive my right to counsel if I didn't have counsel present and there was no judicial inquiry? A lie. These judges lie to cover up. It's the only way Sol Greenberg and the Albany DA's office can win a case is by having the judges cover up their illegal actions. These judges lie to protect the corrupt Democrats, because that's what you don't get elected if you're not a Democrat in Albany County. Especially in the state, county-wide elections. How did I legally waive if I didn't have counsel present? The law is very clear. Now, Governor Cuomo, Hillary Clinton, Eric Schneiderman, Chief Judge DeFore, and Chuck Schumer, you're all lawyers. Tell me where I'm going wrong with this if you can. I'll bet you can't. These judges need to be put in jail, and so does Sol Greenberg, even though he's retired. They've covered up his illegal action. He should not benefit from his state buddies covering up his illegal action. Was the transcript altered? Mason, I made a motion to the court to inspect the grand jury minutes, as it was my position that Mr. Horn made statements to me in order to get me to wrongly incriminate myself, and based upon the fact that I was not allowed to present evidence on my behalf to the grand jury. Obviously, the statements ADA Horn made to me are missing from the record. For example, I did admit that it might have cost $1,500 to clean up after the spraying, and denied that this was damage to the building. He stated, which is not in the record. You want the indictment, don't you? This statement by him is a violation of the criminal procedure law. In other words, he's trying to put words in my mouth. Strong belief that all grand jury proceedings, family court, and all other proceedings should be videotaped with a clock in the background and a timer on the video camera. That way people can check what's on the tape and what's being said with a clock in the background. That way they can take minutes out. Give you an example. When I was talking about Sean earlier, the judge made comments to him. They were missing from his transcript. He called the transcription up and said, in this part, the judge made these statements and comments. She goes, it wasn't there, I would have put it in. She checked the tape. She hadn't turned it back in yet. Guess what? A minute and a half was missing out of the tape because it has the digital numbers, and all of a sudden it jumped. That means somebody, maybe it was the judge or somebody else in the Saratoga County Clerk's office, altered that transcript. Took out the stuff that was the judge made that was derogatory to him. There are two issues that I would point out as well. Become relevant later on. First, appointment of public defender. I was brought before Judge Larry Rosen for arraignment on the criminal mischief charge in the grand jury proceeding. This is an arraignment. Mr. Horn will be informing you what the charges are and may be handing certain documents over to you. You are not in custody at this time. Eventually, if it is your determination that you wish to represent yourself, and that's what I want to get at the moment, I just want you to know that I would certainly give you several more days, even before this arraignment took place, to find an attorney if you wish to be represented by counsel at arraignment. If it is your desire to represent yourself in this manner, so-called self-representing, which is your constitutional right, by the way, I will allow you, for that purpose of the arraignment, to represent yourself. I would set it for a few days from now. It's not really a hearing, but a more official method of me asking you all sorts of questions on the record to determine whether or not you represent yourself in this proceeding. First off, there are two issues that I would point out. First, Judge Rosen stated that if I elected to represent, he would have to have a more formal hearing asking me all sorts of questions. He was referring to the judicial inquiry. This was what should have been done when I was before Judge Herrick. The second is that he had determined that I had not waived my right to counsel as of this date. So where did I waive my right to counsel before the grand jury? I didn't. But they claimed I did. The transcripts, as I said, are on every bit of this. The grand jury testimony, my testimony, is on my website. All this stuff, the transcripts for these hearings, are all on my website. After my arraignment, Mr. Neidel of the Public Defender's Office approached me after court and stated that he would like to represent me in this matter. Little did I know at the time that he was a former Assistant Attorney General and Mr. Greenberg's Chief Assistant. How sweet it is for them. I should mention I never filled out any paperwork in order to see if I qualified for public defender. I wonder why. They wanted their own boy in there. Grand jury hearing. Now, when you appear before the grand jury, one, you have to waive your right to counsel and stuff, which I never did. But waiver of immunity was never submitted to the grand jury. The law is very clear. Under 195 states, upon appearing at such time and place, and upon signing and submitting, in other words, you have to do both, to the grand jury a waiver of immunity pursuant to 190.5. Such person must be permitted to testify before the grand jury and give any relevant and competent evidence concerning the case under consideration. Upon giving such evidence, he is subject to examination by the people. I wasn't allowed to give any evidence or anything. You know, Horn kept interrupting me, and any indictment or direction to file a prosecution obtained or filed in violation of the provisions of paragraph A or B is invalid. A or B. B is right here. I have to sign and submit. In violation of provision of this paragraph is invalid, and upon a motion made pursuant to section 2 must be dismissed. You have a certain time limit. I think it's 10 days to file it. I filed it within 5 days, I think. The signing and submitting are distinct acts which requires both to be done in order for a defendant to have waived their right to immunity. 2 appeals court rulings. People v. Stewart. Court of Appeals ruling. 1998. This is just before that. A. Waiver of immunity is not effective unless and until it is sworn to before the grand jury conducting the proceeding in which the subscriber has been called as a witness. Under the statute, subscribing and swearing to the waiver of immunity before the grand jury are distinct acts that must occur for there to be a valid waiver. They're saying subscribing and swearing are both the acts, 2 separate acts, just like signing and submitting are. Where a waiver is deemed ineffective, a grand jury witness is rendered immunity from prosecution for all acts or transactions that were the subject of his grand jury testimony. This is Horn. Would you please state your name? I did. Excuse me. I'm a part-time paralegal. And you are aware the grand jury in Albany investigating an incident? Yes, that's correct. And you have decided to proceed here pro se. Is that as your own attorney? Correct. That's correct. And you are aware that under CPL 190 you have the right to and have an attorney present in the room with you during this proceeding if you desire so. And if you are unable to afford one, you will be provided one for free of charge. Is that correct? That's correct. Okay. Now you were charged with, where did Horn inform me of any rights or get a waiver of immunity that complies with the law? This is it. This transcript is on my website. He didn't. So right there, this whole thing proves I never waived my right to counsel. Saying you're aware of it, that's fine. We're going on. That's not what it said. Where did he tell me the advantages or disadvantages? He didn't. He's not even a judge. He can't have a judicial inquiry. Where did I waive my right to counsel? The law states very clearly, a person who appears at arraignment without counsel does not waive his right to counsel. You can't be any more specific than that. 2 charges, and you have been indicted, indicated in your capacity as your own attorney that you wish to testify and give evidence before the grand jury. That's correct. We go through the whole thing. People v. Higley provides a waiver is not effective unless and until it is sworn to before the grand jury as a witness. I never swore to it. He didn't swear to it. Where the legislative has unambiguously required that a waiver may be sworn to before the grand jury, and where legislative has unambiguously provided that a waiver is ineffective unless and until sworn to, it is not for the people to fashion a substitute for the procedure. Affirmation addressing the issue, A.D.A. Horn wrote, that with respect to defendant's contention that on the record before the court, the people will be unable to establish that the defendant executed a valid waiver of the grand jury, said contention is totally without merit. He lies. A.D. Horn did not attempt to explain this erroneous assertion. He just makes it. At a hearing on March 3rd, 1999, Mr. Horn, the final exhibit I have I previously discussed with Mr. Neidl so that I didn't have to have the grand jury stenographer come in and testify is a copy of the standard Albany County waiver of immunity and form signed, unsigned by the defendant, but it is a photocopy of the blank that was used in the case. He doesn't have my waiver of immunity. The stenographer, granted, in the testimony it says I was signing something. They referred to it. But who knows if it even complied with the law? Nobody knows. They said their standard form. Well, if he doesn't have it and it wasn't submitted, I'm entitled to immunity. He got caught with his pants down around his ankles, to put it short. The court, that will be the people's 9. Shouldn't even have been taken into, it's not signed or anything, it's a blank form. Now it gets better. Neidl says, I acknowledge it's the standard form of the district attorney, but I certainly am not going to stipulate that it's an exact duplicate of what my client signed. With those factors, I'm going to allow the people to introduce that as People's 9 and evidence with the conditional objection by the defense to be noted. I would like to inquire where the original waiver allegedly signed by my client and have the district tell the court. Either that or he is going to have to testify, but I think he can just tell the court it's missing. Your Honor, this is Horn. The last time I saw the signed copy of that, it was in the possession of Mr. Collins in the grand jury. If you read the grand jury minutes, there's a whole big discussion on me signing an alleged waiver of immunity. After that, I don't know what happened. There is absolutely nothing in the transcript saying I submitted it to the court. And in both are required. All you politicians and judges understand this? You're all attorneys. By ADA Horn's own admission, the last time he saw the alleged waiver of immunity was in my possession. Therefore, I could not have waived my right to immunity because it was never submitted to the court. When I submitted the waiver to the court, he could not state this as the waiver was never submitted to the grand jury. That is supported by the grand jury transcript, as there is no mention of it being submitted. It is undisputed that ADA Horn allowed me to testify without submitting a waiver of immunity to the grand jury as required by law for me to waive my right to immunity. Therefore, I was entitled to receive. ADA Horn and Greenberg's office the judges couldn't allow this to happen 4 times. It would really show what assholes they all are and how they're stripping people of their rights. Manure suspect sues district attorney told me after I filed this, drop the charges, it'll be better for you. Bull, I should never listen to attorneys. Accused of showering court of liquid. A Troy man allegedly wears Greenberg denied the Collins allegation, which was saying the judge and his office told Collins of his right to an attorney. Yeah, they said you have the right to an attorney. The question is, where did I waive my right to an attorney? In other words, he's telling you something that's true, but he's lying because I have to waive my right to counsel. Just because they told me I'm entitled to it does not mean I waived my right to counsel under the law, which I didn't do. Greenberg has no integrity. Judicial conduct. Judge K. A judge shall respect and comply with the law and shall conduct himself or herself at all times in a manner that propose public confidence in the integrity and impartiality of the judiciary. A judge shall be faithful to the law and maintain professional confidence in it. A judge shall be patient, dignified, and courteous. A judge shall take an initiative of appropriate disciplinary measures against a judge or lawyer for unprofessional conduct of which the judge may become aware. That has never been done. They all know what each other's doing, the unprofessional conduct of stripping people of their rights, especially Judge K. The commission concluded that there was no indication of judicial misconduct upon which to base an investigation of the judge. I filed several of them in the 90s, complaints against the judges and everything. And it is the Judicial Cover-Up Commission. They refuse to talk to you, the office is locked, and they will not even answer the door. What are they hiding? They will not answer questions, their responses are short. We can't talk to you. It is not a court of law and does not have appellate authority to review. I'm not asking for appellate review. I'm asking them to do their job. The Commission on Judicial Conduct protects the judges, not the public. Yeah, a few times a year they'll nail a judge for something he's done outside, but they're not going to nail them for what the illegal actions on the bench. It's cover up, cover up, cover up. That's why I filed those complaints. This one here. A judge shall not sit as such in or take part in a decision, action, or claim, matter, motion, or proceeding in which he has been an attorney or counsel or in which he is interested. Statute requiring disqualification of judges in basis of interest or bias is jurisdictional. So in other words, if a judge has something to do with it, it is illegal. Disqualification. A judge shall disqualify him or herself in a proceeding in which his or her impartiality might reasonably be questioned, including but not limited to circumstances where the judge has a personal bias or prejudice concerning the party. Well, do you think Judge Case got a personal bias or prejudice against me? I think so. I know so. The judge knows that he or she, individually or as a fiduciary, has a financial interest in the subject matter in controversy or in a party to the proceeding, or any other interest that could be substantially affected by the outcome of the proceeding. We're going to get into Judge K. Despite the court's subjective view of the matters resolved impartially, a judge has an independent duty to disqualify himself in any proceeding in which his impartiality might reasonably be questioned. The issue then is not the court's capacity to sit in a fair and honest judgment with respect to the controverted issue, but rather a reasonable member of the public at large, aware of all the facts, might reasonably question the court's impartiality. This is an objective standard, and where the question is closed, the judge whose impartiality might reasonably be questioned must recuse himself from the trial or from the case. After I did this, I was denied. They said, nope, I didn't waive my right to counsel. I had counsel. I waived my right. How, I don't know. That my filing of that their blank sheet was sufficient. They wouldn't address that it was never submitted. They had no proof it was signed or what I signed. But that's okay in Albany County. This is how they cover up for each other. Defendant had a personal, this was the suit I filed against Judge K, because after being denied that, I filed with the Court of Appellate Court, denied Court of Appeals. Disqualification. No, actually, I filed a federal suit against Judge K of the court. Defendant is that Chief Judge of the Court of Appeals. The Court of Appeals building. Now, let me ask you, I'll give you a little example first and then it'll relate to this. You rent an apartment. You're being evicted. You get served with the papers, you go to the court, and you walk in, and guess who's sitting on the bench is the judge? Is the building manager. Not the owner of the building, but the building manager, who is paid by the building owner who is suing you to manage the building. Do you think he should be hearing the matter? Of course not. He's got a bias, he's got an interest, and he's getting paid by the person that's trying to evict you. Well, the same thing appeared here. We've already gone through this. One of the things I discovered, purely by accident, was all state buildings are under the control of the Office of General Services. The state capitol, the legislative office building, all the other properties that are owned by the state are all under the direct control of the Office of General Services. There is only one exception in New York State. Do you know what that one exception is? It's the Court of Appeals. The Court of Appeals, Judiciary Law Section 60 states, the Chief Judge of the Court of Appeals shall have supervision and control of the Court of Appeals building in the city of Albany, with the grounds and premises adjacent or appurtenant to or connected therewith belonging to the state, so far as such grounds or premises now and hereafter shall be laid out and completed. She technically is the building manager of the building. She's got the supervision and control. In other words, she's got no authority to rule. 83. Judicial Law 14. A judge shall not sit as such in or take part in any decision or action, claim, matter, motion, or proceeding to which he is a party or in which he has been an attorney or counsel or in which he is interested. Don't tell me Judge K wasn't interested. Also, I sprayed the Court of Appeals building under her control, so therefore she should have been disqualified on that also. But she was definitely disqualified because she is the de facto owner of the building. She has the supervision and control of the whole building, to clean up everything. Defendant ruling on appellant's motion was a denial of due process in violation of Judiciary Law 14. Defendant was not acting within her judicial jurisdiction, as case law in states that clearly hold that she had no jurisdiction to rule, as she was prohibited by law from hearing the matter because she had a direct interest in the outcome of the proceeding. She was acting in complete absence of all jurisdiction. Case law again. Statute requiring disqualifying judges based on interest or bias is jurisdictional. Requiring just on basis of interest or bias are jurisdictional in nature. Defendant does not have immunity. If there is state statute, and we're going to get into this a little later, it's very simple. If there is state statute or case law that expressly deprives the judge of jurisdiction, judicial immunity is lost. She has no jurisdiction whatsoever. A state judge who ordered this, that was in Stump, that one held that because there was no law that precluded it, he had immunity. But if there had been a law, he would have lost his immunity. In this case, she did not have immunity. And there are two cases. The big one is Rankin versus Howard. Mills, and also Mills. A judge who knows he knows he likes or acts on face a clearly valid state or case law expressly depriving of judicial immunity is law. Now, one thing you know, judicial immunity is only when you sue a judge in their official capacity. It has nothing to do with criminal law, which she was also a violation of. And it just goes through the stump when he knows and there's another one. A judge knows he likes or acts on face of clearly bound statutes or case expressly depriving of judicial immunity is lost. She didn't have any immunity. Even out of the Second Circuit, a judge will not be deprived of immunity because of action he took was an error, was done maliciously, or was in excess of it. Rather, he will be subject to liability only when he has acted in clear absence of all jurisdiction. She had no jurisdiction. She was deprived under the law. McAvoy. Although the court has a duty to show liberality towards pro se litigants, and extreme caution should be exercised in ordering sua sponte dismissal of a pro se complaint. He does it all the time. He did it to me every time. He's never let me proceed with all the allegations I've had and the documentation against the judges. He is the number one. First off, he's a traitor to both the state and federal constitution, but you can bet he's the number one federal terrorist in the Northern District of New York. Another thing, before adverse party has been served and the parties have had an opportunity to respond. That Judge McAvoy's action dismissing my complaint prevented me from being able to argue that the defendant was acting in clear absence of all jurisdiction. He didn't want to hear it. It was dismissed before she didn't even have to answer it. That's how fast he worked. Ruling, this order simply takes the position that the defendant had immunity from suit because she is a judge. He refused to look at anything that disqualified her from having immunity. And then he signs it. The law in this circuit provides Judges enjoy absolute immunity from personal life for acts committed within their judicial jurisdiction. That's true. But she wasn't in her jurisdiction. The absolute immunity of a judge applies however erroneous the act may have been and however injurious in its consequence it may have proved to the plaintiff. No, that's not what I argued, and he didn't address it. She was deprived by law from ruling. She had an interest in the case. And of course it's dismissed with prejudice. Now, you get our illustrious Court of Appeals in New York City, who just like to follow through with everything. Appeal from the judgment of the court. Upon due consideration, it is hereby ordered the judge to decree that the judgment said that is hereby affirmed. What else are they going to do? They're going to protect K. Plaintiff acting pro se filed a complaint against the defendant K. Plaintiff alleged that K violated plaintiff's constitutional right to appeal the denial of his state habeas corpus petition, which challenges criminal mischief conviction for spraying the Court of Appeals building with chicken manure. Chief Judge K had issued an order denying plaintiff's motion for leave to appeal denial of habeas Supreme Court Appeal. Third Department. The substance of plaintiff is that as the official charged with the supervision and control of the building, and as such allegedly affected the smell of the manure, Judge K was disqualified from ruling on plaintiff's motion. In a decision to dismiss the act, the court acknowledges that it must exercise extreme caution in ordering sua sponte dismissal of a pro se complaint before the adverse party has been served with and the parties have had an opportunity to respond. The court also noted, however, it has a responsibility to determine that a claim not frivolous before permitting a plaintiff to proceed. The court then dismissed plaintiff's claim as frivolous because circuit law grants judges absolute immunity from personal acts committed within their judicial jurisdiction, and because K had jurisdiction to deny plaintiff's motion. How the hell did she have jurisdiction to deny my motion when she had an interest in the building? This is how the Court of Appeals in New York State, the Second Circuit, covers up for K and all the other judges. They don't want to address the issues. I've already had 3 or 4 plus other people's filed for the rights to a public trial, jury trial, court of proper jurisdiction. They never once addressed any of the issues. They just affirmed the lower court, and they say she had jurisdiction. She was disqualified by law. They're issuing a certificate that they know contains a false information, denying me my constitutional rights of due process and equal protection of the law. This is how corrupt these judges are. And everybody laughed at Donald Trump. These judges are Pierre Laval, Jose Cabranes, and Robert A. Katzman, circuit judges. They're a disgrace. They're traitors to the United States Constitution and the laws. And not only that, they're terrorists because they're allowing these illegal actions to go on. Now, last but not all, argument of the constitutionality of the criminal mischief statute. Now, I again had the same attorney I had for the one that got my other charges dismissed for doing the work, do my appeal. And he did an excellent job. In my appeal, my court appointed Paul Connolly argued that the constitutionality of the state statute, he did a much better job of explaining it. His argument defines criminal mischief. A person is guilty of criminal mischief in the second degree when with the intent to damage property of another. I had no intent to damage any property of the other, and I didn't damage any property. Wait till you see what they come up with. And having no right to do so, nor any reasonable ground to believe that he has such right, he damages property of another person. An element of this offense is damage to property. Now, basically what an opposed written decision, Supreme Court attempted to explain it. Initially the court noted that the evidence adduced at trial indicated that the exterior marble facade of the New York State Court was not physically damaged. There was no chips, cracks, structural harm, nor permanent stains were caused. Of course not. The court did not specifically state whether there was any physical damage to the banner. Yes, the court did. All it had to do was be aired out. Oh, well, the court didn't. The court went on to cite Random House Webster's Dictionary second. Now we're going to a dictionary. Not the previous case law, but the dictionary. Injury or harm that reduces value or usefulness. The court then stated that if spraying liquid chicken feces on the Court of Appeals reduced its usefulness, I don't know how it did, or involved loss of efficiency, that would be sufficient for injury to find damage. No, that's damage to the owners. That's not damage to the building. For the following reason, it's submitted this is erroneous. Here, was a temporary reduction in usefulness of the building, but it was not due to damage to the building. There was no damage. The building was undamaged. The cleanup consists of removing a substance from the outside of the building. The starting point of any statutory interpretation is, of course, the plain meaning of the law. In common parlance, reference as instruments within the meaning of the term is used within the penal law. I'm going to give you a little different example which shows what he's basically saying. You just buy new clothes for your kids. They go outside, they jump around in the yard, they get their clothes all muddy and dirty. They come in, you take the clothes off them, you wash them in the washing machine, you bring them out, and they're clean. Would you say that your children damaged their clothes when they went outside and played? He used the example of you have a car. You drive it through a pasture where there's cows and all types of manure and everything gets on your car. You go home, or your four-wheeling or whatever, and your four-wheeler gets all mud. You go home, you wash it off, all the mud off. You wash the cow manure and everything else off your car. Would you say your car was damaged? That I had to have it repaired? No. When you think of damage, you either have to have it repaired or replaced. One or the other. And if it doesn't need either one, it's not damaged. So saying the usefulness of a building, who would know that the usefulness, if you block an entrance or something, that's criminal mischief? Nobody, except these judges. Now, there was a case, matter of James and William H., 2nd Department, 1969. This is 2009, so that's a long time before this. The court held was a juvenile delinquency proceeding where the respondents were charged with committing what would have been criminal mischief had they been adults by writing obscenities with chalk on the victim's driveway. Cleaning removed the offense of writing. Dissenting opinion. The appellate court held that the petition should have been dismissed for there was no evidence of actual damage to the driveway within the meaning of section 145 of the penal law. So you got 3 judges holding it, 2 were dissenting. Here, as a matter, there was no damage to the property at issue. Its physical exterior was unimpaired, the cleanup was necessary. Damaged property needs repair, or if damaged too much, replacement. Merely sullied property needs neither repair nor replacement, but only cleaning. The property at issue, the Court of Appeal, was sullied, but it was not in need of repair or replacement. It was no more damaged than a brand new car defiled with chicken manure or the driveway in the Williams case. As noted in the post-verdict decision, the Supreme Court stated that the evidence adduced indicated that the exterior marble of the building was not physically damaged. And the banner wasn't. They just held it up over the police department, left it outside to dry out in the elements. There were no rips, no tears, or anything else to it. So how was that damaged? It wasn't. Pursuant to that interpretation, had the defendant sprayed the offensive liquid on the road in front of the Court of Appeal, causing a powerful stench within the building, he would have damaged the building. This is how obscene their thing is. If you want to take it a step farther, look at Occupy Albany. In Albany, you had Occupy New York. Look at what they did to all around the state capitol and down in New York City with the tent city and everything else. Streets couldn't be walked on. There was shit all over the place. Drugs all over the place. Up in Albany, they tore up all the lawn where they were camping out, dug holes in it, threw garbage all over. 24-hour police had to be around the place. Not one of them got prosecuted because they're Democrats or they vote Democrats. So they get a free ride after causing all that damage. They caused a lot more damage than I ever thought. I didn't even cause any damage to the building. They caused the lawn, the seed was all dug up from them walking on it, pitching tents, sleeping on it. It was a mess, but that's all right. The banner, the arguments made above with respect to the building applied with no less force to the banner, which was not even cleaned, except by the elements. There is every reason to believe that had the banner really been allowed to continue hanging exposed to the elements, it would have soon been as good as new. But I had to pay for a new one, even though this one, there was absolutely nothing wrong with it. In sum, the banner needed only cleaning and thus was not damaged for purpose of the criminal mischief. Didn't even need cleaning, it just needed to be aired out and let the weather take care of it. Now, in Bright, in a challenge to the constitutionality of a penal law on the grounds of vagueness, which is what we're doing, because we have court rulings saying that there has to be physical damage to the property, which there wasn't. It is well settled that a two-pronged analysis is required. First, the statute must provide sufficient notice of what conduct is prohibited. Well, it doesn't say anything about a building. It doesn't say it's vague. It doesn't say whether it needs physical damage or not. They're saying we're going to use Webster's dictionary. That doesn't mean that's correct. Every state has different laws, phrased differently. Must provide sufficient notice that conduct is prohibited. Second, the statute must not be written in such a manner as to permit or encourage arbitrary and discriminatory enforcement. A criminal statute is unconstitutionally vague if a person of reasonable intelligence reading the statute would not apprehend that it proscribes the conduct at issue. Believe me, I took every effort to make sure there was no damage done to the building. How would I know that spraying the building damages the building when there is no physical damage to the building? To me, if you need to repair something or replace something, if I had sprayed the windows and the window broke, that would be criminal mischief, depending on the value of the window, which degree, to replace the window. But nothing was broken. If the statute is so unclear that a person of ordinary intelligence, due process requires that men of common intelligence should not be forced to guess the meaning of the criminal statute. No one may be required, at peril of life, liberty, or to speculate as to the meaning of the penal statute. That's exactly what they wanted me to do. Speculate. You got 3 judges ruling this different than what these guys did, and they were out to nail me. My rights were, from beginning to end, as I've already documented, was violated. They're not going to address this. I had no intent. I couldn't show the proof of what my intent was to get a public trial to expose the corruption in the Court of Appeals. That wasn't allowed. My intent was, because I sprayed it, therefore that was my intent to damage the building. That was not my intent. And if you look at everything else I've done, that certainly supports my argument. It is here submitted. A person of ordinary intelligence reading this statute would not conclude that it does not prescribe the defendant's conduct, for the conduct did not damage the Court of Appeals building, but rather dirtied it. As discussed above, the term damage is not commonly understood to include dirtying or sullying, which does not impair physical integrity. As I said, your children's clothes. So now you can go out, if your kids damage their clothes, you can have them arrested for criminal mischief, for dirtying their clothes out in the backyard playing. By driving a motor vehicle on a muddy dirt road and thereby muddying the vehicle, he had damaged it within the meaning, nobody would say that they damaged their building by getting it dirty. Everybody that goes to a car wash that's clean their car, you don't say, I'm going to the car wash because I damaged it because it's all muddy. You say, I'm going to the car wash to clean the car because it's all muddy. There's a difference. Judge K, after this was over with, made the ruling, ordered on the court's own motion that the appeal being the same hereby is dismissed without cause upon the ground. No substantial constitutional question is involved. That said motion for leave to appeal being the same is hereby denied. This was after I was convicted. She ruled on this. No substantial constitutional question. What about my right to due process? My right to equal protection of the law? My right to immunity under the state statutes? Because I never submitted, I don't know what I signed. There's no proof of what I signed, except they got a blank letter, piece of paper. It was never submitted to the court. So there's no proof of what I signed. There's no proof I submitted as required. Judge K is nothing but a lying whore. She is the state's #1 whore, prostitute for the judiciary. She is stripping everybody of their rights. This is what the Democrats do. Albany County is controlled by the Democrats. Judge K is a Democrat appointed by Mario Cuomo, Andy's father. Nobody wants to address the constitutionality. They want to screw everybody in this state. How many people have been illegally imprisoned in Albany County in this state because Greenberg and his thugs, and that's what the ADAs are, thugs, are having the cases fixed, and then you have the ADAs fix the cases. I then went into the Court of Appeals, or the district court with it. They go through the background again. I'm denied. I'm looking to get out on a habeas corpus. My rights were denied under state statutes and under my right to due process, the right to counsel. Of course, this is all these documents are in my paperwork. The ruling and everything else. He just blows it off, comes up with all this stuff I didn't do. Wherefore, that the reason stated above, this act is dismissed without prejudice. Collins, within 30 days of filing this order, files an amended petition which demonstrates the state remedies. I did exhaust state remedies. You only have to give the state one shot at the Court of Appeals. I did with Kay's ruling. Oh no, at this point I didn't. I then filed another one. Oh no, this is the one. This is Sullivan. I proved it. I had Kay's ruling. This was May 22nd, 2000. Okay, he did this one. Then I went through, again, Spain, made the ruling. Another Democrat who screwed the other people in their rulings out of their rights. Peter Liska saying he doesn't have right to restitution and they're not going to do anything. He's out $60,000. You know, he doesn't care. He's not going to do it. He's ruled in a couple of my matters. He doesn't care what the law is. He's out to screw people. I wonder how Spain or any of these would like it. Like Spain got 16 grandchildren. I wonder how he'd like it if one of them got sent to jail in a secret proceeding where they weren't allowed to present evidence. Everything is hidden. They're not given counsel, and if they are, the counsel blows them off. I would bet you he would be arguing his tail off. He doesn't believe in the rule of law. He's a terrorist. His law firm in Troy is a terrorist organization because he is a terrorist. Anybody that would go to the Edward Spain law firm should stay away from it. He has screwed so many people over. You want to support somebody that's out there screwing and has screwed people out of everything? This is what he's up to. This is what he does. First, the record belies defendant's claim that he did not effectively waive his right to counsel at his arraignment in Albany City Court. He's saying I did. But the statute says, even if I waived it at City Court, I didn't waive it after my arraignment. You cannot waive your right to counsel. He's lying right there. The transcript of the colloquy between defendant and the court clearly reflects that the defendant was advised of the nature of the charges against him and the right to an attorney. He declined. But I wasn't informed of all the other rights. Everybody reads the orders. Nobody goes back and reads what the legal arguments were. And this is where they screw everybody. Because they're not published. The only thing you get to read is this. They're lies. But you don't know that these are lies unless you've read what the legal arguments were before the court. There should be a requirement that before they write everything and say it, they have to put in the full argument of what the person and then why that's not right. It would cut down on the corruption because they'd have to, and if they don't, this is a false instrument. They don't care because nobody's going to prosecute them. I've already gone over the transcript and why Herrick's didn't comply with the law. As right to an attorney, declined assistance from the unequivocally say I will represent. I was given no other choice, and I stated my reason was that they lied to me. They didn't properly represent me. But he doesn't have that in here, does he? Thereafter, county court conducted evidentiary on defendant's pro se motion to dismiss him and correctly concluded that city court had appraised the defendant of his right to and properly permitted to proceed pro se. He didn't give me all my rights. It didn't tell me the advantages and disadvantages. The testimony and evidence at the hearing fully support concluded that the defendant was very knowledgeable about his rights as a defendant in criminal proceeding and had knowingly and intelligently waived his right to counsel at the arraignment. How? I wasn't given any information. I'm not a lawyer. But I research. And a lot of this stuff you find out afterwards. Not while it's happening to you. A lot of these, when you get screwed, you go back to the books and you start looking up to find out what you can find. And I'll tell you, a lot of the stuff I found was by pure chance, pure luck. People were finding based in part on city court's past dealings with the defendant wherein he demonstrated sophistication and extensive substantial knowledge in criminal matters. The defendant invoked his right to testify before the grand jury, acting pro se, and the grand jury minutes reflect that prior to testifying, the defendant was apprised of his right to counsel. But again, where did I waive my right to counsel? I didn't. I couldn't have, under the statute, and Horn is not a judge to have me waive my right. He should have taken me out of the courtroom, taken me before a judge so all that can be done. But they were in such a hurry to get me indicted and get it over with, they didn't do it. Especially waived that under oath, and after the waiver of immunity was explained, defendant reviewed, executed a written waiver of immunity, and swore to it before the grand jury. Defendant's contention to the contrary notwithstanding, the evidence submitted at the hearing before county court, including the grand jury, established that the defendant effectively waived his right to counsel, executed a valid waiver of immunity, which was submitted to the grand jury. Horn stated it was in my possession the last time he saw it. There is nothing in the grand jury minutes stating that I submitted it to the grand jury. So it states I signed something. This is how they lie. Judge Spain and these other judges are all terrorists. They're traitors to the Constitution. They're traitors to both the state and federal constitutions, and they are terrorists. They're terrorizing litigants. They're fixing every case. I've already gone through several cases. These judges belong in jail. And New York State needs to clean up the judiciary. But the politicians won't do it because they know the judges will cover up for them. And then they denied my argument on the damage to property. The testimony of the Court of Appeals established that the putrid stench sprayed from it lasted for months. Well, that's not as much stench that comes out of the Court of Appeals, what these judges do. As Kay says, look at the court. We're doing such a great job. She's delusional. It's what you don't see the court doing. Behind the scenes, stripping people of their rights, not letting the issues come before the court. While no such damage is provided, it is commonly recognized that the term constitutes injury or harm to property that lowers its value. Doesn't say that. How was the building's value lowered? It's state property, but where was the value of the property lowered? It wasn't. It needed to be cleaned. You don't say, well, I dirtied my car, I had to take it over to the car wash and clean it. Oh, by the way, because I had to take it to the car wash, the value of my car just dropped $100 or $200. This is how stupid their arguments are. But it looks good. Likewise, nowhere in the Supreme Court has charged the jury that damage means injury or harm to property which reduces value or usefulness. It didn't reduce the usefulness of the building. People were able to go in and out afterwards. They were able to file papers. The court held sessions. They didn't close the court down. Everybody worked in their offices. Might have been a smell, but that didn't prevent anybody from doing their work. There was no testimony that it prevented anybody from doing their work. Further, the proof adduced at trial sufficiently established that the amount of damage to the property greatly exceeded the statutory threshold of $1,500. There was no damage. There may have been damage to the owner of the building, the state, for cleanup costs, but there was no damage to the building. The cost of replacement or destroyed banner, including the cost of rent and purchase equipment. Well, that's not damage, rent to purchase equipment. The cost to replace the destroyed banner. The banner wasn't destroyed. That was in the testimony. All they did was air it out on top of the police department, and they stated there were no holes, rips, or anything wrong with it. The nature took care of cleaning it. And he says destroyed banner? What a bunch of malarkey that is. And the cost of labor to complete the prolonged extensive cleaning process. Again, that's not damage to the building, that's damage to the owner. The testimony of the building adequately established the monetary value of the labor expended by the Court of Appeals employees to restore the building. They didn't have to restore anything. They had to clean. There was nothing to restore. It was not damaged. Nothing was broken. Nothing needed to be repaired. This is how they lie. And we discern no error in the inclusion of this cost in the calculation amount of damages to the building. The damages are not to the building. They're to whoever owns the building. Building doesn't pay the bills. The owner pays the bills, to put it quite simply. To the extent that the defendant challenged the verdict as contrary to the weight of evidence, we conclude that based upon the overwhelming evidence adduced, a different verdict would have been unreasonable and reject this claim outright. Well, of course. They don't want everybody in the state spraying the Court of Appeals building or every other state building. Even though I didn't break the law, what I was charged with, With regard to defendant's contention, appeal is unconstitutionally vague and failing to provide notice that conduct such as his constitutes damaging property, the statute is presumed to be valid and defendant has not met the heavy burden of demonstrating its unconstitutionality. I think I did very well on, or the attorney, Paul Conley, did an excellent job on explaining it. It's vague. Nobody would think that spraying something that you have to clean and it makes it fine again is damage to the property. Or that mud getting on your car, you wash it off, that you have now damaged your car. That's malarkey. So how would you know that putting mud on somebody's car, you're actually committing criminal mischief if they have to wash the car off? Makes absolutely no sense. Examine defendant's remaining arguments and determine their lack merit. They don't want to address anything. It's corrupt. I then appealed to the Court of Appeals on this one. And I got a new judge. Because I already sued Judge K, so she couldn't rule. So now they picked the newest judge on the bench to take care of it. Because he was appointed after I did the spraying. And it wasn't Judge K because she knew she didn't have jurisdiction. I, Albert Rosenblatt, Associate Judge of the Court of Appeal, do hereby certify upon application, time you made in the above, for a certificate upon the record and proceedings here, there is no question of law presented which ought to be reviewed by the Court of Appeals and permission is denied. Permission is denied. In other words, all my rights are gone. They're not going to touch it. Rosenblatt. I appealed to the Court of Appeals after that ruling, addressing every single one of these issues. Again, all these motions, my paperwork is all on my website, justicefornewyork.com. He denies it. No constitutional question. I'm denied my right to counsel at all during this court proceeding. I never submitted the papers before to the waiver of immunity to the grand jury. They didn't even have the waiver of immunity to produce to say I submitted it, and the transcript of the grand jury minutes don't. And I have no right. Now, here's the problem. I looked up Albert Rosenblatt, and I looked up Judith K. And if you read Judge K's bio, and there was something in the newspaper of Judge K sitting on the bed in her house with legal briefs on it. Her husband's over here, and she is over on the other side of the bed. And she's talking, they're saying how at nighttime the two of them used to go upstairs and they go over the legal stuff on the bed before they went to bed and everything, discussing all the different cases and everything. Well, let me put that into translation for you. The translation is, Judge K and her husband used to sit on the bed deciding how they're going to screw litigants out of their constitutional and statutory rights before they screwed each other. My question is, did he have a brown bag with a happy face or a sad face on it? Rosenblatt. Oh, and let me also state, Judge K also states in her bio how her and her family fled Poland after the Holocaust to move to the United States. Rosenblatt in his bio states half of his family, his father's family, was wiped out in the Holocaust. You got two people, two judges on the Court of Appeals, the chief judge and an associate, who were both affected, their families were affected by one of the most horrendous things that went on during World War II. And yet, the two of them or repay America for what America has done for them and their families. She was an immigrant to this country. She becomes Chief Judge of the Court of Appeals. How does she repay America? How does she repay New York? By stripping the citizens of this state of their constitutional rights. Both of them. They're both a disgrace to this country, to the state of New York. They're both traitors. They're terrorists. They're no better. At least the Nazis didn't take an oath of office to defend and protect the state and federal constitutions like they did. I'll tell you, this is what the Democrats are about. They are going to be, if you elect Hillary Clinton, the Fourth Reich. You won't have any rights. Your guns are going to be taken away from you. Your families will be taken away from you. We'll have concentration camps in this country. Because that's what they're after. They're stripping our rights away from us. And this is how these people repay America? The New York State? And both of them. Not only were they paid $80, $90, $100,000, $115,000 a year or more to strip us of our rights, they collected pensions. He's still collecting a pension. I don't know if he's on the bench now or not. I don't think so. But even if he is, he's collecting money from the state to strip us of our rights. They belong in jail. This is what they're doing. How do you think they'd like it? And especially coming from what's happened to their families, and they want to do the same thing to us? Both of them are anti-Christian. Make no mistake about it. They do not believe in the rule of law. They are terrorists. They're traitors. They're terrorists. And something needs to be done about it. I wonder how Kay would like it if her property was taken and put someplace else, given to another party, in a secret proceeding where the person's told to get out, like my mother. My mother had no substantial right, according to Kay, when she appealed to Kay. This is a horrendous, what these people are doing. And they make them out like, and if you read anything on them, they'll always say they have such high integrity. They have no integrity at all. They're worse than the common thugs on the street, because they're affecting thousands and thousands of people with their illegal court orders and rulings, destroying us. I then went back to the Court of Appeals after Kay's, saying I was denied my rights. Again, Judge Scullin denied it. The first time this one, I argued I exhausted when I went through Kay. He still took the position I hadn't exhausted my state court remedies. Anything to screw people out of their rights. This is what the federal government does. They're there to protect the corrupt judges and attorneys in New York State. And they are just as bad. Petitioner has given the state courts, including the New York court, a fair and full opportunity to decide and apply controlling federal law to petitioners' federal constitutional claims raised in his petition for writ of habeas corpus. Exhaustion of available state remedies requires presentation of the claim to the highest court from which a decision is had. However, a petitioner need not give the state court system more than one full opportunity to rule. I gave it to them, which Kay denied in my habeas corpus. It states here, has been interpreted to require that the prisoner need follow but one proper procedure to raise merits of his alleged federal question in state court. State courts need not have decided the merits of the claims raised by appellant in state court in order for him to be considered to have exhausted state court remedy. They just kept dismissing it. I'm falling within this. Based upon the above, the petitioner has now exhausted his state court remedies. And I cite all the different statutes and everything. Two-pronged test. Fairly presented as federal question to, believe me, as I said, you can read it. Whoop. I shouldn't have, but I got denied again. And then when I finally did it the third time, they didn't want to hear it. They said I didn't follow a proper procedure. They can't grant the relief from state court. They don't have the authority to do anything, which was a bunch of malarkey. No one. They don't like that I stand up. They don't like that I go after I document what the judges and how their illegal actions are. These judges have to be held accountable, both the state and federal judges. They're corrupt. They need to be removed. And it's about time, Chuck Schumer. Why don't you call for a hearing in the United States Senate to go over what these federal judges are doing and how they're depriving litigants of their federal rights in federal court. It won't happen because it's in your state and you're a coward because you won't do it. You're there to protect you are friends with every one of these corrupt judges, I'm sure, because they're all Democrats just like you. And you need them to get elected and glad hand with you and everything else. Put an end to it if you're a man. Otherwise you're a coward. Same with you, Eric Schneiderman. Why don't you do something? These are all written false. Let me go before a grand jury and present all this. It won't happen because they don't want the truth coming out. If I ever got before a grand jury going through this, half the judiciary would be in jail right now. The family court, the criminal courts, Albany court. If you're involved in Albany court, you demand, before you even start, that the judge give you all the information. Demand it. I'll tell you, I've demanded in other courts for other people. They won't give it. Demand that they give you your rights. It's on the transcript. Demand your public defender do discovery. Demand it. If they don't do it, write a letter to the court saying they're refusing to meet with you. They're refusing. How do they prepare a case when they say, come in, and you're facing a minimum, you say even 6 months in jail. You're a Class B misdemeanor. You're entitled to have these public defenders. And I'll tell you right now, if you're in Albany County and you're getting Judge Herrick that's now going to run the public defender's office, it's not going to be happening. It'll probably be even worse because his sole thing is to work with the judges and to cover up the DA's office, to cover up their illegal actions, and it is his actions in depriving people of their rights. And he was a judge required to do that. He didn't do it as a judge. What makes you think he's going to do it as a public defender? The other thing is, for Dan McCoy, county executive, get rid of James Dixon and Mr. Horn. Fire them. They're depriving people of their constitutional rights. If you want to sit down with me, I'll be more than glad to and go over all this with you and present all the evidence. And they need to have their law licenses by the state of New York stripped from them for violating a person's rights. I know, well, the court said otherwise. I've already documented how corrupt the court system is, how corrupt Albany County is. Get in there and start demanding all this stuff. I will tell you, you can bury Albany County in paperwork. It will cost them millions of dollars. So if you're charged in Albany County, start costing them county money. They deserve it. They think I deserve to be stripped of my rights? They deserve to make sure people get their rights enforced. And that they have public defenders that are actually defending the litigants instead of being the district attorney's, what do you want to call it, assistant? Because that's all they are.